All right, we're on the record. The case is 2023 J0508 Equity Residential Management LLC versus Paul Delgallo.
Okay, good morning, Mr. Delgallo. Good morning. Is it Attorney Nato?
Yes. Good morning, Your Honor.
Am I pronouncing your name correctly?
You did. Thank you.
Good morning, Your Honor.
Morning, sir. Here today, I just wanted to set a few ground rules first. It'll be 15 minutes per side. Mr. Delgallo, you'll proceed first, and then Attorney Nato representing the plaintiff. After Attorney Nato is finished, there's no chance for rebuttal, Mr. Delgallo, so your first chance is your only chance. And I want to let the parties know in advance of the argument that there are two issues of which the SJC, the Supreme Judicial Court, has recently accepted review on. It's a case that's Frechette versus Dennis Brown, a landlord-tenant case, not too dissimilar from this case. And the issues, as reported initially from a justice in the appeals court, the first question was, may or must a trial judge in a case involving an indigent party for whom the appeal bond has been waived, or ongoing use and occupancy payments pending appeal otherwise permitted or required by Chapter 239, Section 5E, to be waived, substituted, or paid by the Commonwealth as an extra fee or cost under the Indigent Court Cost Law, Chapter 261, Section 27A through G. First question. Second question, may a trial judge order a defendant in a summary process action for whom the appeal bond has been waived, pay ongoing use and occupancy pending appeal pursuant to Chapter 239, Section 5E, in an amount that exceeds the defendant's ability to pay without violating that party's due process, equal protection, or Article 11 rights. I wanted to let the parties know that the Supreme Judicial Court will be reviewing those two issues that granted review, I believe, a week ago today. I also wanted to let the party know I've read all the filings. I've read the filings of Justice Kelleher of the Housing Court. Is it Justice Winning?
Justice, I believe, Dalton. Or sorry, Chaplin.
Chaplin, thank you.
Captain Kelleher, yes.
And I've also read all the party submissions. One issue that may be relevant for parties to address. I have Justice Kelleher. You have a different Attorney Nato?
No, so the trial judge was Justice Kelleher. The motion judge on the use and occupancy was Justice Chaplin.
I see. But the order on defendant's motion to waive appeal bond other costs, that again was Justice Kelleher, correct?
Correct.
And Mr. Delgallo, you were not at the proceeding before Justice Chapman, is that correct?
That's correct. I requested an emergency hearing. I had an auto accident, and during that hearing, instead, they heard the use and occupancy motion, which I had not filed an opposition for and was not present for.
And so the only other issue I wanted to raise for the parties is that one issue that may be relevant is whether there's a meritorious defense pursuant to the statute. So with that said, I'm going to ask Mr. Delgallo now. You have 15 minutes to present your case, sir.
Thank you, Your Honor. Pardon me. As you're probably aware, I'm not an attorney, so just bear with me. I've been a tenant for 18 years, always paying on time, and in total, I've been a reliable payer of both rents and mortgages for 35 years. My last yearly rent was $60,000. When COVID hit, my lease was about to end, it was renewed annually. It's just up, and they offered to renew the lease and then pursue funding through RAFT, which I agreed to do because there are constraints upon my residency. It's not easy for me to move. I have custody of my children. I have requirements, et cetera. I don't want to belabor it, but it is not an easy move. So I agreed to do it. And the way the process works, and only just to enter it up on the record, the landlord and the tenant have to work together to obtain a RAFT grant of this size. And so we did that. And at that point in time, it is portable. I could have left and pursued it with a new landlord, but did not for a variety of reasons, including this was the agreement we came to. Caitlin Jasmine was the person I was coordinating with, and this is of relevance. And she told me that they had been pursuing the RAFT grant and they had heard back from the coordinator that it was coming in, there would be at least the balance that was due. She then informed me that she was switching positions. I asked if she had coordinated with the next individual. She said she had. At trial, we learned none of this was true, that she actually was not responsible for coordination of RAF grants and presented what she presented when she did. I then got a call in January saying from Attorney Nadeau saying, you owe us $70,000. I said, geez, I was told that there's this grant coming in. What's its status? And he said, nobody's double dipping here. You have to tell us how you're going to pay this or we're going to begin summary eviction. I wrote back, I gave him a copy of the emails that we had exchanged, and they immediately began summary eviction anyhow. During the course of that process, then in June or July, they sent me notification that they were terminating my residency here, that I was to turn in my keys and fobs and go through the vacating procedure. This was, of course, out of step with the procedures that go into summary process, and I had put in counterclaims and I had asked for a jury trial. Then the RAF check award came in. Now, in between, Attorney Nadeau had written to me and said that I wasn't to communicate to anybody at the plaintiff except on emergency maintenance issues. The process from RAF or Metro Housing or whatever name we give it is to go and work with the landlord and decide what amount you want to apply to use and occupant ongoing and what goes to back rent. And they, in their brief, mentioned that I owed an alarming $73,000. I want to be clear. That's really using cash-based accounting. Accrual-based accounting, there might have been $5,000 due. And if I'd gone back out in the marketplace to find a place, I'm a guy with a 35-year history of on-time rental and mortgage payments. Now I'm a guy going onto the marketplace looking for residency, facing all sorts of demands, and you can envision it. So I don't use my time pro. Anyhow, when I was brought to my attention the award, Attorney Nadeau sent the front but not the back of the award letter. At the award letter, essential to the difference between it and the current case before the higher court, and that is that on the back of it says that if they accept the grant, tenancy would be reinstated if no eviction had started, no eviction based upon the grant amount, and any such eviction process would be halted. So by and large, given the closeness and proximity, given the size of it, that should have terminated this case. But I was sent only the front side by Attorney Nadeau, but the two sides, which I put in my exhibit, show pretty clearly the requirement. So I contacted Metro Housing and I said, what do I do? I said, I wrote to Attorney Nadeau and I said, how would you like to allocate this? And he wrote back and said, is what you're asking what day you can vacate? That's clearly different than the grant provides for. So I filed an emergency motion. I asked the judge to hear my motion to amend the counterclaim for fraud and to make an allocation, right? To basically take the funds that were on hand. I did have an auto accident. I believe it'd be relevant for you to know. I've never missed or been late to a hearing or a document or any other thing. One small thing happened. Nobody was injured, but that's what happened. So during that hearing, as the tapes will show, they held the use and occupancy discussion. And I'm waiting for the tapes, but I'm confident they didn't say, oh, we've received a $68,000 check. We could look at doing that. Now, even if they did, Judge Chaplin would have erred in her discretion in not making some form of allocation given it. But she'd never heard the argument. This is a new process. She didn't have the chance to hear, hey, they shouldn't accept the check. I want to be clear, Your Honor, as you know, but to enter on the record, the RAF grant is portable. I don't have to use it with the landlord I'm with. I could pick a new landlord and have 18 months and then go figure out what to do with the old landlord. But instead, we didn't cancel it because I didn't know exactly what to do. And so at that point in time, the jury trial was canceled. And I was not then in a subsequent hearing, I was not allowed to place the counterclaim of fraud. I believe that was, first of all, to be clear, they never answered my counterclaim until December after that. So this all happened around August. So I might have even been able to file an amended counterclaim saying it hadn't been answered, but I didn't. I tried to follow procedure. I understand that I'm not attorney pro se. But without a doubt, it was an abuse of discretion. An amendment to a counterclaim of this type, given these development of facts, would have been a natural. It's well within all of the courts, including, I think, Rule 15 for here. So at that point in time, we then, bear with me one moment, please. I just want to make sure I don't repeat myself. So then we went to trial, and I did not present a trial. Okay. And the argument of fraud was not allowed to be presented. And we learned during the trial that, in fact, I had been misled, that Ms. Jasmine and Attorney Nadeau came forward and said that he had a long group of experience, that I was coordinating the grant through him, that had extensive amount of experience in handling charities, et cetera. A phrase I take offense to, because this was I'm a man who's paid his taxes for 54 years, and in an emergency, the state granted me some relief, right? And I don't mean to raise that like this is an entitlement, but to deal it as a charity is incorrect. It's what the legislature, the executive, and the executive orders designed to prevent exactly what's happening now. And this goes to my absurdist argument. The intent was clearly to keep people in residence. And I give the description of the intent of it, which was spelled out in great detail, to make sure that people could keep residency, people with 2 handicapped children like me, to still prevent landlords from suffering unneededly, which I wholeheartedly stand by, and concurrently to make sure that we don't create a housing crisis in the middle of the COVID outbreak. I have been an exceptional tenant, I want to point out again, for 15 years at extraordinary rents. I was and I run a consulting business that got stopped. So while I respect Judge Chaplin, I believe she made an error in discretion, and I believe that Judge Kelleher, I apologize, erred in that he always followed whatever she had ruled. He didn't reverse in any context. So he said, well, she ruled that you aren't entitled to use this for use and occupancy, and that you aren't entitled to a jury trial, and I'm not going to do anything to reverse that, and that's his. But the discretion I'm bringing into question is that, and there are really 2 main arguments that I'm using. The first is, just let me apologize. I'm not very good at.
No, no need to apologize. Take your time.
Thanks so much. Is the case around Davis? I believe. I'm sure I'm giving the wrong name. No, Davis versus Comerford. And that really deals with takings and other such situations where there's a counterclaim that the legislature has built into the allocation, that there could be a counterclaim that would offset use and occupancy. I believe I have a valid counterclaim for $68,000. I believe that when I file my appeal, in terms of having a legitimate appeal, that they first of all should have terminated the proceedings upon accepting the check. Because the condition of the check, the condition of the Commonwealth, is that you stop those proceedings. But second of all, and that was clearly spelled out and agreed to, and it turned out that the person who entered in that agreement, Heather Grundy, was in communication with no one else. It turned out that the people who terminated my lease had no communication about a pending RAF, and they were all not telling the truth, and that only came out at trial. But the bottom line is that it is proper to take such an allocation. Now, as you mentioned, for the case that's pending, and I apologize for not being fully up to speed on it, whether the state should stipulate in to cover it. Well, I'm claiming they already did. I'm claiming that the state has provided $68,000 for use and occupancy. I'm going to have an extraordinary amount of trouble switching where I reside now. Now I go from pardon the way I say it, the guy you want to get for a tenant, an 18-year tenant at $60,000 rents, to a man under this. And I'd have to concurrently get my hands on enough to both pay the use and occupancy and then come up with whatever sum of money I'll need to convince a landlord to take me. Those are astronomical sums. I can't make it. I'm getting by with what I'm borrowing from my son. Now my business is returned, right? And I'm happy to update financials as we go along. But my business is based upon years. It takes 180 days to get an engagement, 180 days to finish the engagement, 90 days after that to get paid. It was very fun to go around and tell people I was a high-flying consultant up until it came out to this, because I'd already built the business. That is taking place. But the theory provided in Davis is that I not only should be able to provide these offsets, but as I think you're raising with this case that you cited, I'm entitled to due process for my appeal, which has merit. I believe I'm going to actually prevail in the appeal. I believe that I have a legitimate argument that even if they don't believe that the case should have terminated by accepting the check, that there's an act of fraud in accepting the check. And with that, then right now what I'd have to do is basically I'm going to face eviction. They've already filed on the first day. They filed to have me evicted. September 6th, even though I'd already filed here for the review, they went in and they asked the court to begin evicting. Okay, so there's no intent to arrive at an equitable solution for everybody. Nobody denies that they're entitled to rent. And on top of it, I do have to raise, and I dislike the phrase, just as a non-lawyer, it's as cited in their own case, which is 21st Century, and several that I cite that I'll cite again here, is the idea of an absurd outcome. The absurd outcome being that this grant that was put forward by the legislature and then through executive order and executive intent was to prevent exactly where they're arriving. They're going to actually take the check and put me on the street. And I want to be clear with the court, that's what's about to happen. And so that's an improper outcome. That was not the intent. And if they want that outcome, the proper relief they could go seek is with Raft and Metro Housing and go, look, we should be able to take the check and continue to evict this person. There's a reasonable argument. I don't believe I have standing to make it, that there was a fraud, obtaining a signature through fraud here, through obtaining a signature through false pretense, right? Because they got me to agree to be the plaintiff on this, or to be the tenant on this, and they didn't follow the stipulations, and they were very clear. And the deceptive practice of hiding page 2 is alarming. Now, with that said and done, we get to then the other cases that I have cited, and I've done the best I could in the very brief amount of time I had to cite the other occasions that it was there. But I believe that the court probably recognizes and understands that the absurdist outcome is that the state would give equity $70,000, $68,000 to not evict me, right? And so that I could work out whatever I had to work out, and instead they would evict me and keep the $68,000. There's no debate in all of the documentation, which I try to cite within my brief, that was the exact opposite of the intent, right? Right, to make sure that people stay housed and that they get what they're entitled to. There's no debate between me and equity about me leaving, and I have no objection if I believe that the proper allocation is to take the use and occupancy and apply it to the $68,000 check. And therefore, while the appeal goes on, if the appeal ends before the $68,000, I have no objection to it being applied to the balance. But that's the proper use. That's the non-absurdist outcome. That is the logical outcome for the plaintiff, to accept the grant and not pursue eviction. Now they're decided to pursue eviction, but what they've done is basically monopolize the grant by delays, which I proved at trial, right? That were caused by the plaintiff. The check was later than could have been, right? Now, Metro alleged fraud, and that is what it is. But nonetheless, if I could have gone somewhere else with this check. I'm entitled to use it, and if not, it's well within your discretion to knock down the amount to one that I can somehow find to pay to avoid, again, an eviction they pursued September 6th, right? And I believe I have a counterclaim. I believe it will overwhelm the use and occupancy. I have no objection to residual use and occupancy going back to the balance. But this is my position. I have a minute and a half left. I have a couple other data points I want to make sure I get in just because of it. And that is that I apologize. I went faster than I thought I might. I apologize. That when interpreting the statutes, appellate courts take great care to avoid any sidestep interpretation of statutory language that culminates in an illogical outcome or goes against the legislative intent. That's 21st Mortgage. That's their own case that they cite. Right now, I admit that in that case, the defendant, and not to badmouth anybody I haven't met, was obviously pursuing an absurdist outcome. They had received an eviction and tried to attach themselves to a resident. But the argument runs in both directions. There's no reason to believe that accepting a $68,000 check on certain conditions should ever benefit the plaintiff if they don't follow those conditions. They basically kidnapped the funds and prevented them from being used for what they were desired. I can't believe, and I'm comfortable in saying, given the language that I've included in the briefs, that the intent of the legislature and the executive was anything besides to avoid exactly where we're at right now. And then I apologize, Your Honor. I just want to make sure I get everything in that I wanted to. As well, although I guess I won't give the additional citations because I don't want to give you what you already have. I do want to point out that I do believe that a better brief could have been written if we hadn't received a filing at 4:30 a.m. of the last oral hearing. I'd really appreciate leave of the court to be able to combine this down into a single document that's more cogent. I'm not a lawyer. I don't usually bring that up, but because of this sort of trial by ambush approach, I've been a little bit stuck. I'm happy to answer any questions, Your Honor, but
well, that's fine. Your time is up. I do have one question. I believe it was in 2020 you negotiated a reduced rent. Is that correct?
Well, my lease was renewed at a lower amount, but that was based on the negotiation. What happened was, and I didn't want to belabor this because I believe this was trial court issue, and the rent came up for $60,000 a year, around $5,000. I came to that, and it literally at the start of the outbreak, and I said, look, I'm probably not going to renew, but I really don't know what to do. And they said, well, if you don't renew, we're going to start charging you $6,000 a month, the month-to-month rate that we have. And I came back and said, well, I couldn't possibly do that right now. Nobody knows what's going to happen next, and I'll have to move during COVID. And so they came back and said, well, so there was a bit of a debate. So I went out online and I identified what they were currently charging for new tenants. And I said, look, they're going for 39, the same apartment. I mean, it's a large building, just to tell you what you know. And I said, this is the price they're going for online. Obviously, if I leave, you won't get that for some period of time. Why don't we do this number? And they agreed. And they said, well, let's do that and then pursue funding. And they did. And in the trial process, there was just, that I took through, and one of the issues is that not all of the evidence was allowed into the record, but they chose of their own volition to go in this route. And I point out that they had an enormous benefit from it. They didn't wind up with an occupancy at the start of COVID.
Thank
Any
you,
other
Mr. Delgallo. Thank you. Attorney Nato.
May it please the court, Eric Nato for the Plaintiff Appellee Equity Residential. Your Honor, this case came before the trial court for non-payment of rent. Straightforward, as Mr. Delgallo has stated repeatedly, that he was not able to pay. Jumping straight to the RAF allocation, Mr. Delgallo worked with Equity and their team to get the RAF award of $68,543.14. Where nobody's disputing that amount. The dispute appears to be that whether or not we could proceed with a balance that still remained due after allocation of the $68,000, which, based upon the ledger that the court has as Exhibit A to my opposition, the balance due at that time was $25,304, which is further buttressed and solidified with the court's judgment award of $57,157.18. If we are to go with Mr. Delgallo's logic and approach, then we would have had a much larger balance due. We would have ignored the $68,000 and the balance would have been over $100,000. But that's not what the judge found. The judge found that after allocation, there was still an amount due. We did not go forward on the amount of $68,000 that was paid. It was only on the rent that was due subsequent. As far as the standard for an appeal bond, as the court's aware, it's Mass General Law 239, Section 5E. And even when an appeal bond is waived, which in this case it has been, the court must establish a fair market value of the premises, which is what the trial court did. In the trial court, Judge Kelleher actually used the agreed upon contract rent that Mr. Delgallo negotiated himself as a fair market value. He also found the judgment for plaintiff on all of defendant's counterclaims, which were the one that I believe he briefs is that there was a period of time where he was unable to use the exterior balcony due to the replacement of the guardrails. That is not inside of his apartment. The court did not credit that as a proper 239.8A offset, and the court issued correctly that the portion of rent due going forward or use and occupancy going forward for the appeal would be $3,769, which Mr. Delgallo is not paid and does not appear to be able to pay. What Mr. Delgallo is looking to do is drag this case out for as long as possible, engaging in a dilatory tactic after dilatory tactic, claiming that the trial court doesn't know what they're doing or have any grip or grasp on the law, all of which are not true. The court's orders are very clear. Mr. Delgallo had every opportunity to present his evidence at trial. In fact, Judge Kelleher's order details that he gave him an opportunity to present evidence of fraud, which there was none that was presented at trial. So to Mr. Delgallo's point that he has meritorious defenses and that he could withstand this trial, that's just patently untrue. He does not have an 8A waiver, and the court did not find any evidence or any indication of any fraud whatsoever. If you were to look at the RAF documents that were presented, the first page actually says on the left-hand side, the amount of arrears. And then there's a whole nother section on the right side of the document that's for stipends. Mr. Delgallo is looking for the court to reallocate what the allocation was from Metro Housing Boston, which was up to 18 months, which is no longer in play, but at the time, up to 18 months of back rent and or future stipends. Well, Mr. Delgallo exhausted his 18 months of back rent at $68,500 and change. There was nothing left to be put forth towards this maintenance charge, as Mr. Delgallo will have argued. He's looking so that the court can require RAF to make the money that he was receiving for arrears for future payments, when that was not the allocation, nor, if you look at the second page and the two bullet points quoted in reference in Mr. Delgallo's appeal, he's trying to claim that we had no right to proceed. It's very clear you cannot proceed on amounts that were paid, but we didn't proceed on amounts that were paid. We proceeded on the $25,000 balance, and currently, Your Honor, he owes over $107,000, and it's accruing at $5,000 a month, and there's no end in sight if Mr. Delgallo is unwilling to vacate. We believe that the judge correctly ruled that the use and occupancy would be $37.69 based upon the contract rent as agreed by Mr. Delgallo. The court did not credit any of the diminution in value allegations or charges by Mr. Delgallo. And the law is very clear, understanding that the Supreme Judicial Court is currently reviewing those two questions as referenced by Your Honor. As it currently stands and as it's currently constituted, Mr. Delgallo is required to pay something going forward. The agreed upon amount and the amount found by the trial judge was $37.69. We believe that that's appropriate, and we'd ask that this court stand with the trial court and not disturb the ruling.
So in his findings, Justice Keller did, in waiving the appeal bond, make a determination that there was, and it's a low bar as he cited, but there was a prayer of a chance for a meritorious defense. Did you want to address that?
To the extent that the bar is extremely low, I mean, Mr. Delgallo had every opportunity to present his defenses, and he presented, I believe, if I recall correctly, 174 exhibits on the eve of the last day of trial, none of which assisted him with his presentation. He's alleging fraud, which the proper party to address that would be Metro Housing Boston, not the plaintiff. He's alleging that there was a diminution in value, which the trial court already addressed. He's alleging that there was a 93A deceptive and unfair practices for, as he mentioned today in the hearing, not presenting him the second page of a document he was already in possession of. In fact, Your Honor, there's no defense to his non-payment. As he mentioned in this hearing, COVID came and COVID happened, and I didn't know what to do, and I couldn't afford it, and we just worked something out, and we were all kind of wondering. So again, it's Mr. Delgallo has no option but to fight this case on as many appeals as possible because he has nowhere to go, as he's stated today. And to suggest that he has a meritorious defense based on pure speculation, it's not appropriate for this court to consider.
Well, I don't think Justice Keller, based on pure speculation, he was a trial judge, correct?
Yes.
Was it your understanding, you served notice for your intent to evict, that there was a second raft pending, or was there a second raft application pending?
So at the time that we served the notice to quit and commence the summary process action, there was not a raft application pending. It was subsequent thereto. Now, I do note that there were two applications filed by Mr. Delgallo. The first did not come to fruition. The second one did, and it was in the amount of $68,543, which was specifically allocated to arrears, as is required pursuant to the Metro Housing Boston process. There was no money left for any future stipends, as Mr. Delgallo argues. And it's very clear that we are not entitled to go forward on amounts that are covered by the payment, which, as the ledger demonstrates, on June 27th of 2022, there was still a balance of $25,304.88, which is what we proceeded upon and what we prevailed on at trial.
Very good. Are you resting on your papers at this point?
Yes, Your Honor.
Exceeding your time. I want to thank you both.
Your Honor.
Two very well argued cases. And I'm going to take this matter under advisement, and you'll be